You're watching Beyond Market. Welcome. I'm Esther Awuni. Many thanks for joining us. On today's show, we'll discuss an arbitration case that could see Nigeria lose about $9 billion in assets to an Irish-owned oil and gas firm over an aborted gas project. You can join today's conversation with the hashtag Beyond Market, so you can send your comments, your thoughts to my Twitter handle. It's at Esther O. Awuni. Now, an arbitration award by the United Kingdom's Business and Property Court on a deal from 2010 in which the Nigerian government agreed to supply gas to a processing plant in Calabar could see Nigeria strip of about $9 billion in assets if the decision is enforced. So how did Nigeria get into this sticky situation, and what are the options available for Africa's largest economy? Taiwo Oyedele, partner and West Africa tax leader at PwC Nigeria, and Adeoye Adefulu, partner at Odujinrin and Adefulu, join me now for today's discussion. Thank you, gentlemen, for being here today.
Thank you. Thank you.
So this, it's been a story that's been trending for a while now, and there are different mixed opinions on, first of all, how Nigeria got into this situation, and it would just seem like this story just came out of the blues, and here we are, or here the Nigerian government is having to, or possibly could be stripped of $9 billion worth of assets. Adeoye, let me start with you. How are you processing and interpreting this story? First, the fact that, it dates back to 2010, and then several years later, we're here talking about $9 billion.
Yeah, well, it is very unfortunate, and I think it's a series of missteps in terms of the signing the contract. It's not necessarily bad to sign the contract. The contract itself was about stripping wet gas, associated gas, which is usually flared, stripping that of liquids, and then using that gas locally, primarily for our gas to power. So there was nothing wrong with that project. But what seemed to happen was that the Nigerian government had an obligation, and that obligation was to provide the gas. And provide the gas meant getting the gas from wherever it was being produced and putting that in a pipeline to where this Irish company, P&ID, was going to process the gas. Unfortunately, the Nigerian government did not move on that element of building the gas pipeline. Hence, we are where we are. And it's really about the principles of sanctity of contract. So if I enter into a contract with you, am I obliged to fulfill that? And if I do not fulfill the terms of the contract, what are the implications for me? And we are seeing what the implications are today.
How that is playing. Taiwo, let me bring you in here, because there's still some gaps and some gray areas in this story, especially on the Nigerian part. This company has come out to give its own side of the story. It's actually on its website for those who want to go there and see the full story. But from the point where it says that the Nigerian government did not provide the necessary infrastructure, fulfilling its own part of the bargain. So, I'm just wondering, questions around why the Nigerian government, why that didn't happen, why the Nigerian government didn't fulfill its own part of the agreement. What do we know in terms of why that didn't happen in the first place?
Yeah, unfortunately, we do not know enough, I would say, especially from the Nigeria side. We do have a lot of information put out there by the company, P&ID. And that makes sense because they are the guys who have something to gain in all of this, especially, looking at the size of the award. But I think it's a fundamental thing that we need to look at very carefully in Nigeria. How we sign contracts, how we negotiate them, the type of and the level of due diligence that went into those contracts, including those that we're still signing. I remember there was a time, recently, I think it was the former finance minister who said that Nigeria belongs to so many international organizations and we don't even pay our membership fees. So this thing that people just think is okay over a coffee to sign and just move on is not ideal. Like I said, we do not know the details of this particular contract as to what Nigeria should have done and didn't do from Nigeria's side. We do know what the company is saying about, we invested, you didn't meet your own commitment, you didn't supply us wet gas, we couldn't do it. And they also said that they made the effort to renegotiate. to get Nigeria to do something about it. And it's surprising to me that if we didn't do anything, then we should have at least been able to communicate to the right people and stakeholders. And even from a transparency and accountability point of view, a country is like an entity where you also have to report, including your obligations. So when you prepare your accounts, what are you reporting? Is there something else we don't know that Nigeria is sitting on? Also, I will question the quality of oversight, even by the National Assembly. So we are very reactive. If something happens and it's there in the press, people are talking about it on Twitter, everybody jumps on it. We're waiting for the next problem to erupt, and then we try and do fire brigade approach. So for me, I'm concerned. One, because this is very huge in terms of the amount. In context, actually, so $9.6 billion is about 3.5 trillion naira. That's more than the entire tax collection that Nigeria made last year. VAT, company income tax, education tax, and personal income tax by all the 36 states, excluding petroleum profit tax. So this is like declaring 1 year tax holiday for all Nigerians.
For all Nigerians.
And you still not be able to pay the award.
As a lawyer, interpreting these events. But for you, should the government come out at this point and say, okay, we were not the government in power then, but we all know government is a continuum, and it's on your desk right now, it's on your table, so obviously you have to deal with it. So what do you expect the government to do at this point in terms of communication?
So the facts are kind of out there. So we don't know exactly why the government didn't fulfill its obligations, but I think we can make a fairly good guess. And the fairly good guess is that someone saw this as an obligation that was imposed by a previous government, and therefore decided not to move on it as quickly as they could. And the truth of the matter is the communication now has to move beyond sort of what happened in the past and who's on whose hand that fell. It's got to be about what we are going to do. And the missteps, frankly, are not just missteps of the previous governments. And I say governments because it wasn't just the Jonathan government. The Yar'Adua government also was involved. It's not about the missteps of but it includes missteps of this government. An affidavit or a statement made to the court talks about delays being due to the fact that we just elected a new government and it took us over 4 months to appoint an attorney general. It just speaks so badly about our approach to governance. And I'm not talking about the length of time it takes to appoint a minister, but the fact that even during that time, nobody was able to take decisions or come out and take steps on behalf of the government. That is, as Taiwo said, really worrying, that we have these kind of lapses and we expect the world to stop for our own, for our own challenges, which frankly is not going to happen.
Let's get into the legal journey of this case now, right from 2017, when the company took it to a tribunal in London, and it ordered the federal government to pay back then $6.6 billion in damages. And what's interesting about what the company is seeking or has been seeking was the profit it would have made in 20 years for the 20-year deal. Now the government swiftly, was disputed that and said, look, you didn't even build anything in the first place. Now you're projecting 20 years ahead and saying this is what you would have made X amount in 20 years and you want to be paid that. Apart from that, of course, the interest that accrued on a daily basis, $1.2 million. The government says, look, that is excessive. I was talking to Taiwo earlier and we were asking, who is the bank that's charging you that interest on a daily basis? But Paul, what is your take on that?
Well, so the principle around the arbitral award was that there was something called a repudiatory breach. And a repudiatory breach is that one part of the contract decides just by its actions or inactions that it is not going to meet its obligations. And the other part, in this case P&ID, accepts that repudiation. And the principle of law is that when there is a liability, when there is a breach, the other part is entitled to damages, and the damages would be in the form of what it had lost if that breach had not occurred. And the tribunal held that what it would have lost is the profits that would have accrued to it over the 20-year period. And in the case, he made, I read the award itself, and the tribunal really described its reasoning around that. And the fact that even though P&ID had not done or had not built the processing plant, the reason he had not done so, was because the federal government had failed in its part to build the pipeline. And so, the situation was, and I read this morning, I think it was an article in The Guardian, where we had a similar situation in the 80s when the metro line in Lagos was cancelled and we had to pay out $78 million, and they hadn't built anything either. Yeah. So it's not unusual to find this. Well, 20 years is a long time, but...
Okay, again, I wanted to sort that because I needed to know, if that was an unusual demand. Taiwo, let me bring you in this. I'm in here. Right from 2010, the company has been to the US, been to courts in the US, tribunal in the US, the UK. I'm just wondering, were there several, would you say Nigeria had opportunities and missed those opportunities to not allow this to snowball to what it has become today? Were there several chances that Nigeria could have taken advantage of? Maybe at the point where it was still maybe somewhere around 2 billion or 3 billion, maybe we could have moved in and then just nipped it in the bud? I
would say certainly yes. Because really, I think what we have on our hands now is like the worst case scenario, 9.6 billion. It's difficult to get your head around it. So every time I have to call the amount again. I think that there have been several chances for Nigeria to at least address this and try and prevent it from becoming a crisis, which is pretty much where we are now. So one of it is, if someone says, I should have invested, I should have made money, and potentially money I could have made for another 10 years, if you start from 2010 and you forward it to 20 years. The starting point for Nigeria would have been, let's sit down without conceding. Let's look at the set of assumptions you made. Now, everybody knows anything to do with gas, anything to do with oil. There are loads of assumptions you have to make. You have to make assumptions about the market size, about the price, about all the other uncertainties. And if I would imagine the company that's trying to make a claim will go for the positive ends of all the forecasts. It could be without even considering. Somebody says, by the way, this is not realistic. This is what the price will be of byproduct, which is also a function of the main product itself and also tied to crude oil. And maybe you come down to 2 billion. So your negotiation point is no longer 9.6, maybe something a lot less. So I think it's been a lot of missed opportunities. It's too late in the day, but maybe not. We can't even give up, really, because we can't afford 9.6 billion.
Obviously, at this point, we need to do something. We need to find a solution. So, yes. Gentlemen, I'm going to thank you for your time so far. We're going to just take a short break here, come back, and just talk about what Nigeria's options are in terms of, and also for the company, if they're going to seize assets, where will these assets be, and what kind of assets are available for this company to seize, in the first place. I've been speaking to Taiwo Oyedele, partner and West Africa tax leader at PwC Nigeria, and Adeoye Adefulu, partner at Odujinrin and Adefulu. If you're just joining us, Taiwo Oyedele, partner and West Africa tax leader at PwC Nigeria, and Adeoye Adefulu, partner at Odujinrin and Adefulu, join with me today, and we're looking at, of course, the story around Nigeria standing the risk of losing up to $9 billion in assets. Thank you, gentlemen, for your time so far. Now, before we go into, we're going to bring in the central bank's opinion and, issues around what can be seized. First of all, the Nigerian government says, Adeoye, let me start with you, that it's going to appeal this decision. I'm just wondering, what happens from now? Will there be a stay, or can the government now say, okay, we're going to appeal this, but nobody should touch anything for now?
So that's what the government is asking for, saying they want to appeal and asking for a stay. It is up to the court to grant both. So that is grant the right to appeal and grant a stay on the enforcement. I think the chances are good. in terms of...
You see that could actually happen? I mean, considering where this case is coming from and how many years have passed, do you think a court will still be willing to...
I mean, there are contentious issues to discuss here, and it is worthwhile exploring them. It may or it may not happen, but I think, I mean, frankly, the Nigerian government doesn't have a choice. That's the option that is available to it, which it must explore, and explore very, very aggressively.
Very quickly also. Taiwo, let me bring you in here. We're talking earlier about what are the options for the company in the first place, in terms of assets that can be seized. And obviously, everything points to assets that would be outside of the country. So what kind of assets can this company take from Nigeria?
Yeah, I think, majorly, in addition to the legal options they have of trying to do stay and then try to appeal, I think also Nigeria needs to consider diplomacy. So if you go at the level of government to government, they have their ways. I'm not saying that the UK government would overturn the decision of the arbitration or the court trying to enforce it, but also you can have some meaningful conversations around that. So in terms of the asset that they can potentially seize, Nigeria unfortunately does not have a lot of high-value assets. I would say the primary focus would be on our foreign reserve, which is currently at about $45 billion. But really, this is not money that is free for us to spend, let alone to pay compensation for values that we did not get. I also feel like, we had significant opportunity costs apart from these 9.6. According to the company, potentially this was supposed to help us generate about 2,000 megawatts of power, and it's also clean power, so it's not just power. So that in itself would have been significant in terms of the impact to the economy. So beyond the foreign reserve, sometimes you have countries with high-value vessels, like what has been happening between the UK, the US, and Iran, and then you seize one vessel and everybody's like, wow, we're in trouble. I'm not aware that Nigeria has any of such high-value assets. And potentially also, depending on how this plays out, you could also place a restriction or lien on contracts that Nigeria has. And that could include, for example, contracts already that we have signed to sell our crude.
I was just going to say that perhaps we'll put crude on the table. That's a valuable asset.
So because, of course, they can't come to Nigeria, which is why they have to then hold on to the contract to sell the crude, which usually we sell to other countries. So this also will require the cooperation of more than the British government with the company. It would also require, other countries such as the US and our major trading partners, especially for selling crude oil, like India. I will not rule out the possibility that those countries would agree with the ruling because, of course, you have the Commonwealth, you also have the fact that everybody wants to demonstrate that they follow the rule of law. This also sends the wrong signal, again, reminding the rest of the world that doing business with Nigeria can be very tricky, which is very unfortunate.
Adeoye, let me bring you in here. Taiwo mentioned forex reserves, and I think that the CBN coming out to, talk about this situation also, sends out certain signals that there is actually that strong possibility that this company can get its hands on the forex reserves. Can they in the first place?
So the case now is we're trying to enforce the judgment enforce the award as if it was a judgment of the High Court of England and Wales. And what that would mean is certainly in terms of assets that we have in the UK, some of those are vulnerable. I mean, there are still some arguments to play out. There's the argument of sovereign immunity, and Nigeria can rely on that argument with respect to certain of its assets. That argument will not go for assets that are deemed to be commercial. So it is possible that the Nigerian government can make a case of sovereign immunity regarding its foreign reserves. That's an argument that some countries have explored successfully. But
for Nigeria, is that a precedent? Has it happened before?
It certainly happened before for other countries. So that argument can be made. But assets are vulnerable. I mean, not too long ago, Argentina, which has had a variety of these cases arise against it, it had a Navy vessel seized in Ghana, in neighboring Ghana.
Okay.
And so there will be continuous vulnerabilities there. You know, Taiwo talked about crude oil contracts, talked about assets related to some of our treasured national institutions. Those in itself could be vulnerable as well.
Taiwo, the central bank governor also came out and said, look, he's going to defend the reserves. I'm just trying to make sense of, his position, his body language, and perhaps what he's not saying also at the same time. Because, we have this going on, and the central bank governor comes out and says, we're going to defend the reserves regarding this story. Like I said earlier, obviously that tells one that there is a chance, there's a risk that, the reserves could be at risk, as it were. I'm just wondering, what is your interpretation of that statement? We're going to move to defend the reserves.
Yeah, again, I think this is also one example of where the central bank is trying to do the work of so many other people, like we've always seen. To be honest, it's not the legal function of the central bank to ensure that our assets are not taken over by either a company or any other party. Their role is to manage a monetary policy and then manage the reserve itself. But because there's a vacuum, there's someone who needs to say something who is not saying anything. And that should be coming from the presidency. We don't have an attorney general, but at least there should be a sense of urgency about this. So I think the CBN governor is just trying to do his best to calm some nerves and give the impression like this is still under control. I do not have sufficient comfort. For example, I would like to even see the terms of this contract. I worry potentially there's, an advantage of if nobody had signed something in that contract giving tax waivers. I can say to you that if eventually we have to pay anything, we can recoup up to 40% back. Because if you say to me, this is a profit you would have made, and I then reluctantly agree, I say, well, by the way, you would have paid company income tax 30%, education tax 2%, withholding tax on your profit of 10%.
Existing taxes within the law.
Within the law already. But I won't be surprised if somebody signed as part of that contract, there shall be no taxes. So these things worry me again, that somebody is not communicating enough for us to get to a point where we're all comfortable. But hopefully it's not as bad as it could possibly be.
And another thing that's sticking out like a sore thumb here is the body language of the government, like as Taiwo, just mentioned. What is the body language of the government right now? I'm just wondering, if I'm a foreign investor, I'm looking, I'm monitoring this story, I'm monitoring myself. Okay, this government has been put on the spot, and this was a multi-billion-dollar contract that went wrong. This is how many years later. What's going to be my fate if I'm to, come and do business with this country? So speak to that point.
Okay. I mean, just before I do that, I'll talk a little bit about Taiwo's point regarding taxes. The award actually takes into account the taxes that should have been paid.
In Nigeria?
Yes, that's correct. So it was a part of the consideration in making the award. So that 6.6 is inclusive of the taxes. Of the taxes that would have been paid.
Wow. But we still arrived at the
6.6. Okay. So there are two things. The first is the Ministry of Justice, through the Solicitor General, has issued a statement, an emphatic statement, tried to clarify what went on in the judgment, painted, in fact, the judgment as wrong, etc., and has said that they're going to appeal. And that's one side.
So when you say wrong in what sense? Wrong that Nigeria fulfilled its own end of the bargain, or wrong that the 1.2 million interest per day was excessive? What part?
So there were elements of challenged the fact that the award was given, one, that the award was so large, second, that it didn't take into account sort of the Niger Delta factors, which is really strange because...
the conflict?
Exactly. The conflict in the Niger Delta and
which
how that
perhaps
could
made
have
the government,
could have impacted the project and therefore the profitability of the project. So we as a government are saying that this insecurity in the Niger Delta, in our Niger Delta, that insecurity would have affected the profitability of the project. It's not a good look at all. But beyond that, and I think this is the second point of the question you raised, I think we need to be speaking about how Nigeria is someone that observes, or is a country that observes its obligations, that fulfills its obligations, that believes in sanctity of contract. I think that message really does need to continue to go out and to resonate. Nobody is championing that message at the moment. You know, the presidency, perhaps even the Ministry of Justice, nobody's doing that.
We have exactly 30 seconds left. We're going to share that 15 seconds each. Taiwo, how do you see this ending? What's the end game here? What do you see as the end game here?
I think
Long jump, protracted
no matter
case.
how you play it out, Nigeria is going to be on the lose-lose end.
Okay.
We just have to do our best to reduce the level of loss.
Okay, Adeoye.
Let's negotiate.
Again, go back to the table. Okay, we'll keep our fingers crossed and see if that happens. Thank you, gentlemen, for your time today. Appreciate it. I've been speaking to Taiwo Oyedele, partner and West Africa tax leader at PwC Nigeria, and Adeoye Adefulu, partner at Odujinrin and Adefulu. Thank you so much for being part of today's edition of Beyond Markets. Remember, you can watch all previous episodes of the show on our website, cnbcafrica.com. I'm Esther Awoni. Bye for now.